Hello, folks. Good evening. Good evening. Welcome back to Criminal Law and Procedure. I'm Peter Heed, uh, and have been doing criminal law for 48 years. And as you all know, I continue to actively practice criminal law because it is so exciting, it is so challenging, and you can have such a meaningful difference in people's lives and in specifically and in the justice system particularly. I want to encourage every one of you to think about uh, careers that may be connected to criminal law and procedure, of which there are many, from way in the beginning of creating laws, working with the legislature, being part of the investigation executive branch, which means police, sheriffs, federal investigators, all the way through prosecution offices or defense attorneys. You can be part of the court system, court clerks, court reporters, bailiffs. There's just, as well as judges and so forth, to the ultimate degree. And then, of course, the whole system of corrections, counseling, working with victims, victims' rights, victims' advocates is a great area to work in. Working with victims of domestic violence and all sorts of violence, working with children, working with juveniles. The whole juvenile law area has all these various aspects, from investigation to juvenile courts to juvenile prosecutors and defense attorneys to juvenile probation officers to, again, afterwards, we have juvenile centers for mental health, substance abuse, counseling, working with families, just as we have for adults, being a probation officer, a parole officer, corrections officer, working in the appellate court area where cases are appealed. So there's an unending, overwhelming number of fabulous careers in the criminal justice system, and I certainly encourage you all to think about it. And if any of you have any questions or ideas or looking for internships, of course, just see me and talk to me in general. So, again, welcome tonight. This is our fourth class. This is our class covering Wednesday, September 20. And we have a lot to accomplish. You might remember again at the end of last class, we were talking about, again, the various levels of crime, the classifications of crimes, violation levels, the lowest level, misdemeanors, class A and class B, which are crimes, but the maximum penalty is 1 year, and the location for incarceration, if you are incarcerated, which is not very often, but if you are incarcerated, you're going to be at the local house of correction, and you're going to have multiple options for counseling, for work release, for early release, for probation, and so forth. If you're convicted of a felony and you are incarcerated for a felony, and it's again more than 1 year, which is the potential for all felonies, you're going to end up at a more of a state prison or in the federal system, or more of a maximum prison sort of situation. Which again, your sentences are going to be a little different. They're going to be structured with a minimum and a maximum. As we talked about, the minimum can be no more than one half the maximum, and you will qualify parole for in about 2/3 of the minimum. So if your minimum is, you have a 3 to 6, your minimum is 3, you actually qualify for parole in 2 years, and you could actually qualify for uh, other incarceration options such as halfway houses, administrative houses, trustee status, and so forth before 2 years. So there's all sorts of options open to not only assist with the rehabilitation of people in the criminal justice system, but to assist in the home corrections system in order to give uh, inmates an incentive to behave well, to change their behavior, and to try to obviously get out of incarceration early and get their lives going again. So all those options are there. We'll be talking about them a little later. Let me just review and update you on assignments and what I'd be expecting you to do for next class. For tonight, I will expected you to have finished chapters 1 and chapters 2 of our tech, sleb and sleb, and hopefully, if you haven't caught up, you should have enough time to do so. For next class, as I will review again later in our discussion, but I will like you to move on to read chapters 3 and read and review the Shepherd case, State versus Shepherd, which I handed out in our first class and is up on Canvas. That is a class or a case which discusses one of the major topics today, which will be the mental element of crime. Uh, as we mentioned in one of our earlier discussions, all crimes, substantive crimes, have to be defined with two essential elements: an act, actus reus, it's called, an act, uh, and a mental intention to do that act, some type of criminal intention. It can't be, if it's unintentional, it can't be criminal unless you can show that it's criminally reckless or criminally negligent. Most acts have to be intentional in some manner, and you have to have an act. Now, there are some crimes for which it's your failure to act, which is criminal, and those are the crimes for which our legislature has put a distinct and specific obligation on people to do certain things. And if they fail to do those things, it's the failure to act that's criminal. What am I talking about there? Well, such things as requiring you to file your taxes if you're working, your income taxes over a certain level. That's a requirement. If your failure to file your taxes and you can show that it's intentional in some fashion, then you could be held criminally liable. Another example is your failure to register if you're a sex offender now. You're required to register with the police, depending on the level of sex offense, at different intervals. And again, the failure to act can be then criminal, failing to register. But most crimes require an actual action. You steal from somebody in many different ways. You can defraud them, you can use violence, uh, uh, you can scam them, but stealing, taking something with a purpose to deprive somebody, that's a theft type offense. Assault can be all sorts of ways of assaulting someone, from a, a classic assault like punching someone, hitting someone, to stabbing someone, hurting someone, hitting them with a club, even all the way down, say, to spitting on someone. And we're going to also talk about a whole area of law called attempt, which is when you attempt to do one of these crimes, but for some reason don't complete the crime. That's called an inchoate crime. We're going to be talking that in one of our discussions in a week or two to come. And that's a fascinating area. Inchoate crime. Again, one of those weird terms that we have in the criminal law that comes from the common law. So please, we will be talking tonight a little more about the four levels of criminal intention, which are set forth really in all states now in our criminal codes, which come from the model penal code. And those four mental states, which we'll again review many times, I'll be a little more specific, but just to give you an overview, are the highest level of criminal intention is purposely doing something, whether you're purposely hurting someone, purposely killing someone, purposely stealing from someone, purposely abusing someone, whatever the crime might be, the purpose to do it, they being in, and it means thinking about it. It means giving some thought to doing what you're going to do, and it's considered sort of the most serious, the coldest, the harshest level of crime, because you've considered supposedly your options. You're going to have to be held accountable because you're going to be held responsible for that. That's called purposely. The next level down is knowingly. Knowingly requires a prosecution or the state to show that you knew what you were doing when you did it. Doesn't mean you had to think about it for any great length of time, but doesn't mean you have to plan it or premeditate it like you might have to do with purposely. Knowingly simply requires, if you have to know that if you're doing something, you're actually hurting someone, you're punching someone, you're threatening someone, you're stealing from someone, you're robbing from somebody. It's the intention to do that in a knowing way. And it's the second level down. It's a little less onerous to prove from the state standpoint. And frankly, it is probably the largest in terms of volume level of criminal charging as far as mental element because it is easier to prove than purposely. And in many cases, you can show that somebody knew it or had to have known what they were doing when they did it. The third level down is recklessly doing something um, well so outrageously acting that you know you're creating a substantial risk that something's going to happen. Somebody's going to be hurt. Somebody's going to be injured. Somebody's going to be stolen from. It's reckless behavior. That's the third level down. And the lowest level of criminal intention is negligence, criminal negligence as opposed to civil negligence. And now we're getting right to the heart of the Shepherd case, which is why I want you to read that. Because the Shepherd case is really about that fourth level of criminality intention, that criminal mens rea, it's called. The fourth level is negligence, and it's not there's all types of negligence. There's simple negligence, there's civil negligence, and then there's criminal negligence. Simple and civil negligence really means just a failure to use due care. For instance, it's snowing out, you have an obligation to shovel your sidewalk or put sand or salt down on your sidewalk where the public is going, and you fail to do that. Somebody falls, you could be at Keene State. You have the maintenance people, they're supposed to get out there in the winter, and you have an expectation they're going to do this. And if they fail to use that common sense acting to keep the sidewalk safe and somebody slips and falls, someone could be held civilly negligent. That could be sued in action in civil court. Uh, uh, again, you'd have to show somebody has an actually opportunity. In other words, if it suddenly gets icy and suddenly snows, you can't expect they're going to be out there in a minute or two. You have to expect a reasonable amount of time to allow them to do something. That is much different than being a criminally negligent. Criminally negligent, like negligent, you'd have to show somebody is keenly aware that something is dangerous and they fail to do something, or they take some action that they know is like blameworthy. They act in some way. It's not quite reckless, but it's let's say so uncaring and so lack of caution. For instance, if there's a specific area in the sidewalk in front of my law office that we know pools up because it's not drained properly. And every winter it ices over and it's extremely slippery, not just a regular sidewalk. And we know this condition exists. And we do it again and again, and we don't do anything about it. And finally, somebody walks on the ice after a storm, and they can show that we've known about this for months. We had an opportunity to do something about it. We didn't do anything about it. Uh, that might be get to the point of being criminally negligent. Where criminal negligence comes into play to the greatest degree in the criminal law is in motor vehicle accidents, as you can expect. And that's exactly what Shepard is talking about. As you can imagine, there are literally thousands and thousands and thousands of motor vehicle accidents involving cars, motorcycles, bicycles and cars, pedestrians and cars. As we know, one of the most dangerous things you can do is drive. We've all striven to create laws and mechanical, technical advances in cars, such as seatbelts, airbags, a better construction, roll bars, better frames to make motor vehicles safer as we've gone along. But there are still laws that cover motor vehicle accidents and motor vehicle deaths. Now, most motor vehicle accidents are that they're shown to be uh, caused by maybe some lack of care, some maybe civil negligence, and so forth. But if you can show that the negligence is extreme, if it's blameworthy, and where you draw that line is very difficult. As you can imagine, just talking about it now, you can see, well, wait a minute, which acts are criminal and which acts are just civil in nature. And the real answer to that is nobody knows for sure. It's a fact driven case, case by case. But in our law, remember, we look at precedent, as we'll talk about in the common law. In the common law, judges started making decisions. This is sometime after the Magna Carta. Uh, uh, Judges then developed a sort of body of decisions. They would write their decisions down. Other judges would look to those past decisions to help guide them on what the law is in areas of specifics that the general law or definition doesn't cover. And as you can imagine, that is many. Just it's easy to say criminal negligence, but what is criminal negligence and what isn't will vary depending on the circumstances. So, a body of law then develops covering all sorts of different factual scenarios, and the one judge of a current case will look back to prior decisions. That's called stare decisis. That's a strange common law term. The more common term for that is precedent. Precedent. Courts look at precedent to help guide them in making a decision. They do this now, today, just as they did 100, 200 years ago. Well, the key in the Shepard case is that it covered a very tragic accident. I mentioned it in our very first class up in Waterville Valley involving the motorcycle weekend. There was a number of motorcycle folks up here visiting New Hampshire. And on this particular day, there was actually two motorcycles that had been up into Waterville Valley. If you've ever been up in that gorgeous area above Campton, you get off the road a little above Plymouth, drive into Waterville Valley. There's one road in and one road out, and runs along the Mad River there. It's beautiful. This gorgeous mountain comes in the background, and the valley itself is sort of a dead end valley. There is a small road that goes out the other side, but it's a dirt road. So there's generally one 2 lane in and one 2 lane out. And on this particular morning, these two the folks on motorcycles with their spouses. So there was actually four people, two drivers and two spouses, were coming out of Waterville Valley, and Joshua Shepard coming the other way early in the morning going to work. Unfortunately, Joshua Shepard, as it came out in the case, had been out late at night the night before. He hadn't done anything necessarily wrong in the morning, but he'd been out very late and apparently had been drinking and perhaps doing other things. In any result, uh, he is now driving to work and he's tired and maybe he still has things in his system, which unfortunately never got into court because it was never collected properly by the police. But something caused Joshua Shepard, as you'll see in the case, to come across the double yellow just at the time when a car followed by the two motorcycles were coming the other way. So Joshua Shepard going into Waterville Valley, going to work. The two motorcycles were coming out of Waterville Valley. They were following a car. As Joshua Shepard started to veer across the road into the other lane, the car was able to quickly turn and avoid it, just barely. But then the car is now out of the way, and guess who's right in the middle of the road, right behind the car, who were not able to get out of the way, and that's the folks on the motorcycle. They were hit head on by Shepard in his uh, Jeep Cherokee, and as a result, tragically, three of the four motorcyclists were killed. Killed. They never. That was the end of their lives, right there, on a road in Waterville Valley. And the fourth person was one of the passengers, was severely injured, and it was accident was investigated, as you'll see, by local police and state police, and eventually it was determined that Joshua Shepard, the police and the prosecutor thought was negligent enough in his actions to warrant being charged with the lowest level of homicide, which is negligent homicide. Again, purposely, knowingly, recklessly, and negligently. And this case, like so many cases we're going to see, went through this whole process, which we're going to take a look at tonight. And he actually got to trial. As we've talked about, most cases never go to trial. They end up either diverted out of the system because of the filters and safety uh, things we have built right in, the sort of gateways that the sieves that sieve off the weak cases, the cases where there's not enough evidence. So only the strongest cases go forward. Most of those cases end up with some sort of plea negotiation because there's tremendous risk on both sides before you'd have a jury trial. But some of the closest cases actually do go to trial, as this case did, and you'll read in this decision that it did actually go to trial. Joshua Shepard was convicted of 3 counts of negligent homicide and a count of first-degree assault, and he appealed. And as we talked about, we'll spend a little more time on this later. When you appeal, again, you do not appeal the jury's decision. The jury's decision that he was guilty stands. They're 12 regular people looking at the law as the law was given to them by the judge. However, what can be appealed is the judge's rulings in the trial and the judge's instructions to the jury. And that's exactly what Joshua Shepard's attorney did appeal, and it went up to the New Hampshire Supreme Court, which is every state has a Supreme Court. And as we talked about also on a Supreme Court review, if it is a closed cases always go toward whatever decision the trial judge made. Just like in an athletic event, uh, we're into the NFL season now, and if NFL refs make a call on the field and they're going to review it, it goes up for instant replay. And remember, the refs, of course, have to make the call within milliseconds while they're standing on the field, whereas the people in the booth, they get to see the play again and again in slow motion from different angles, and then they make a ruling as to they either support the ref on the field or they overturn it. And if they're not able to determine which way the play went, then they rule in favor of the rule on the field. In other words, if it's not clear, the ruling on the field stands, and that's exactly the way it is in our criminal justice system. If it is not clear that the trial judge made an error, then the ruling of the trial judge, who's in the court, has to make that ruling right there when things are happening. The ruling falls in favor of the trial judge. It's only if it's very clear to the appellate court that there's been a mistake made for whatever reason that they overturn the trial judge. And again, it's the decisions of law by the judge. Maybe it's a ruling on evidence. Maybe it's a ruling on a motion. Maybe it's the instructions the judge gives to the jury that they then decide and use those instructions to decide guilt or innocence that is appealed. Remember, an appeal there's no jury on appeal. That is when there's a panel of appellate judges, and each state has its own appellate system. Most states have a Supreme Court. New Hampshire, we have one major appellate court, our Supreme Court, because again, we're a small state. That's up in Concord. There's 5 judges on our Supreme Court. Vermont, one appellate court, same thing. Massachusetts, they have some intermediate courts and the Supreme Court. Connecticut, the same thing. And in the federal system, you have appellate courts called circuit courts of appeal. That's the way the federal system is organized. Each state depends on how populous the state is as to how many federal circuits there are. Again, New Hampshire, there's one. Vermont is one. Massachusetts, there's 4 or 5 circuits, all of which that end up when appeal happens, whether it's Vermont, New Hampshire, it goes to the First Circuit, which is the region of New England, and the First Circuit Court of Appeals is in Boston. The Midwest is in Chicago. The South is in Atlanta or Miami. The Southwest. So as you can see, it's the federal system. Statewide, each state has, if it's a big state, they have intermediate appellate courts ending up with a state Supreme Court. And then what happens if somebody loses either in the intermediate court, the state Supreme Court, or a federal district court? They have a right to an appeal, right where? To the U.S. Supreme Court. The U.S. Supreme Court, again, the rule of constitutional supremacy is one of those key rules we have. Our constitutional rule is supreme, and the Supreme Court judges have the power to overturn anything that happens around the country. Now, as a matter realistically, they cannot take all the cases that are appealed, and there is a process which cases are reviewed when they are appealed to the U.S. Supreme Court, called Writs of certiorari. It's a fancy term. I don't need you to remember that. Just maybe try to recognize that. It's a writ of certiorari. There's other writs that bring cases to the U.S. Supreme Court. But what happens is there's an elaborate review process, and the U.S. Supreme Court accepts for appeal only cases that are crucially important in law, or they think are merit the review for some reason, or have an impact on one of our fundamental rights, or where there's a real discrepancy between the way several states take a certain issue. In that case, they may want to clear that up, so they take the case. The U.S. Supreme Court usually only takes, well, maybe 100 or so cases a year. So you can see not that many cases get to the U.S. Supreme Court. And when they do, they're cases of great importance. Most cases are simply affirmed by what the state Supreme Court of that state has done or what the federal circuits have done. Uh, Back to the Shepard case, one of the reasons I asked you to read it is not only is it interesting and a realistic case that happened just a few years ago in Waterville Valley, but the ruling by the New Hampshire Supreme Court is really held in high esteem throughout the country. And the wording and the way the New Hampshire Supreme Court looked at what is negligent homicide? Was what happened in the Shepard case negligent homicide? Did it qualify? Or was it something else? The court's ruling has been looked on as one of the most important rulings on that issue in the whole country. And therefore, State versus Shepard is cited as precedent all around the country by many, many other states and in the federal system. So it's a case of very big importance in the country in terms of what the criminal law is. It's a great example of what happens realistically at a trial and then an appeal. So in the Shepard case, you will see actually what happened, and which is a little unique because most cases are affirmed on appeal. In other words, the trial judge is supported generally because if the case, as I told you, is close, it's going to go the way of the trial judge. In this case, you'll see that the trial judge was overturned. Now, what happens when a case is overturned? You might want that. Well, gee, what's the effect of an appellate court, like a Supreme Court or a circuit court, overturning the trial court? Well, I'll tell you what the effect is. The effect is you have to go back to square one and start all over again. And you have to correct whatever mistake was made that the Supreme Court or the appellate court has determined was made. And if you can't correct it, what do you think happens? The case is dismissed or dropped by the prosecution. Sometimes, let's say, evidence is eliminated that the first trial heard, and it's not the jury in the next trial is not going to hear about it. A prosecutor will decide maybe his or her case is much weaker, and therefore will negotiate and accept a lower level plea. Other times, the defense will realize they have a much stronger case, and maybe they will not negotiate and go to trial. And so many times cases are simply dismissed or dropped because of actions taken by the Supreme Court or the appellate court. Simply because, an appellate court overturned something doesn't mean the case is over. For instance, in the Tarnishev case, we've talked about that, the Boston bomber. This is the younger brother that actually had the trial in the federal system, was found guilty beyond a reasonable doubt by the jury, and then the jury, all 12, recommended the death penalty under the federal system, and the death penalty was imposed by the judge, but as you know, that has not happened because Tarnishev appealed, and then the federal circuit court determined that the trial judge made a mistake when he was voir direing the jury, that is, determining whether or not the jury was fair or could be fair, or whether they'd already made decisions because obviously of all the publicity surrounding the marathon bombing. Obviously, you're not going to find jurors that probably haven't heard about it, but you need to find jurors that still have an open mind, still have not made up their minds. And in this case, the circuit court appeals determined that the trial judge had not done a good enough job in going through the potential jurors, and that some jurors with prejudices or biases beyond what is allowable got onto the jury. As a result, they've determined that trial has to be redone, and not the actual trial, but the sentencing phase about whether or not there's a death penalty. Now, prosecution has announced that they will try to do that again, but then and they'd have to get a whole nother jury to do this. It's been opposed by the defense, and the case is on standstill, and it may again be resolved with some sort of compromise plea situation. Obviously, the defense is trying to angle for a sentence that does not involve obviously the death penalty. The state, the prosecution would like then the next step back is life without parole, which is what you can get for the most severe types of homicide. That's first degree murder. The defense would like to have uh, maybe a sentence that allows Tanashev to go for parole at some point in the future. And that's where the case is still being negotiated years later. So you know how many years ago the Boston bombing occurred. And this is how long our system takes to sometimes get through all this. And this is one of the things we talk about. Uh, in terms of speedy trial. We all, the defendants have a right under our Constitution, which we're going to look at in chapter 3 and 4, which you're going to be reading for next week. We'll be talking about how the Bill of Rights and the first 10 amendments impact the criminal system. But one of those rights there is the right to a speedy trial, which is really relative in nature. Speedy is not really speedy. And reality is, speed often helps the prosecution more than the defense. The farther you get away from any event, the harder it is to remember specifics. The more your mind starts to play tricks with you. It's just common knowledge. You've all taken probably psychology and sociology, some of these general courses, and you all know from your own personal experience. Today's mid-September. You know, if I just picked a date and say, "Oh, tell me what happened March 8th in your life this year," we'd all go, "What? I don't even remember March 8th." First of all, I'd have to go figure out what March 8th was. Was it a Monday, Tuesday? What? And unless I consulted a calendar or my old schedule or something, I would have no idea what happened March 8th. Now, if you had a particular event, a shocking event, something that sticks out in your mind, or a celebration, there might be something that makes March 8th vivid. If you were a witness to a crime, you might remember. But again, the farther away you get away from something, the harder it is to remember specifics. Just for instance, think about a birthday party you might have had just 2 years ago, which is not far in a criminal trial. Again, I can remember my birthday celebration, but 2 years ago, I can't remember the specifics of what my presents were or what, what kind of cards I got. And it's just that you just from your common sense, you can see that uh, remembering something yesterday or last week or last month is a lot easier than remembering last year. Just a few days ago, we had an anniversary of 9/11. When was that? 2001. I'm sure most of you weren't even born. Uh, that event obviously is very vivid in my mind. I was a county attorney when that happened. The attack on the towers in New York, the flying the planes, and one of the most tragic events. And certainly people that were closely involved remember. But a lot of people they remember that it happened, but have already forgotten most of the specifics around that. So just a great example of how hard it is to recall details, and the longer you get away from an event, the more difficult it does get to in terms of not only remembering but then recounting what happened. That sometimes obviously works into the benefit of the defense because remember it's the state that has the burden of proof. Presumption of innocence. It's the state that must prove the case. So lack of memory by witnesses is something that actually works in the favor of the defense. And sometimes the longer they can delay a case, the better off the defense will be. What I would like to turn now, as we're talking about some of our basic principles in the criminal justice system, is I want to give you a overview of the process, the procedure. Now, we talked about the substantive law earlier tonight, which means how you define crime. And yet, the crime has to have an act and has to have one of the four mental elements: uh, purposely, knowingly, recklessly, or negligently. Again, unless it is a crime for which the failure to act is a crime. And by the way, without law always has exceptions, but there are actually a couple of exceptions to the requirement of an intentional act, a mental element. Again, 99.9% of all crimes require a mental element. There are obviously, like most laws, an exception to that. They're called strict liability offenses, just to raise that for you. A strict liability offense is an offense for which you're guilty if they can prove you just did it and the act, and they don't have to prove that you did it knowingly, purposely, recklessly, or negligently. They just have to prove you did it. What's a great example? The most common example is DUI. DWI, also driving while intoxicated. The the legislature and the courts have affirmed that, for instance, DUI is so dangerous, driving while intoxicated is such a dangerous event for everybody in the public, and proving obviously that somebody did something intentionally or recklessly or knowingly when in fact you're trying to prove they're intoxicated or they're impaired either by alcohol, drugs, or whatever. The two don't work hand in hand. As a matter of fact, if you allowed a defense, well, they didn't know what they were doing because they were too drunk to know what they were doing. Well, that eliminates the whole case. So, long ago, the intentional element of something like DUI was taken away, and all the state has to prove in that strict liability offense is that you acted. That is, you drove while you were impaired, and they don't have to prove that you were knowingly impaired, that you drank knowing you were going to be impaired, or you purposely got impaired. You said, "Oh, I'm going to get drunk tonight and go drive," or you are recklessly impaired, which is the way I suppose really most people are. They start drinking, they don't realize they're impaired. They get in their car and because they are impaired, and then they have a tragic accident, or they're negligently impaired. And again, because the potential for injury and death is so great, that's a strict liability offense. But again, most cases require the act and the intentionally. Now, what I'm going to turn to now, though, is let's talk about an overview of the process. We've looked at a couple of the little elements to the process. We've talked about arraignments. We talked about bail hearings. Uh, talked a little about trials and juries. Also talked a little about prosecutorial review. But I want to put this in perspective. I want to give you a real snapshot into the overall criminal procedure, which again, most people, you just don't have that understanding of how you get from beginning to end. And this will, I think, really help you throughout the course. Let's just think about this a second. Where does the criminal process start? How does it uh, impact people, and when does it impact people? Well, again, we know that it is the legislature of the states or the Congress in terms of federal crimes that determines what is criminal. That is, what actions or lack of action is so serious that we're going to make things subject to the criminal law. There's many things, as we talked about, in society that society doesn't want you to do. It could be rude. It could be offensive. Uh, you can cheat on an exam at Keene State. You shouldn't do that, though. Don't do that. But what I'm saying is that's not a crime. What it is, though, it's a violation of the Keene State rules, and you can be suspended or disciplined in Keene State if they can, or any college, or high school, or any school, if they can prove you're cheating. Cheating isn't good, but cheating is not usually a crime. It the penalties for cheating are something else. There's all sorts of things that happen in society that are against the rules of your organization or your club or your school or your church, and the penalties for those things are penalties within that organization, or you're actually thrown out of the organization. If you can be in business and you can be penalized for uh, failing to follow certain rules and regulations. Those are administrative rules and regulations, there's a huge area of law called administrative law. Let me give you an example. There's all sorts of rules and safety regulations for construction sites and for uh, people building things, building bridges, roads. You've all heard of OSHA. That's again, the federal organization that overviews the safety for workers in our country. They've passed literally thousands of safety rules and regulations, and most of them, if they're violated, are an administrative violation, and they are penalized financially. The company is penalized if they fail to take certain action to protect its workers. Now, if it can be again shown that they knew something is dangerous and they intentionally or maybe recklessly ignore this situation, they might be charged criminally. But generally, most companies are simply fined. That's an administrative penalty. What we're talking about is criminal penalty. How do things get started? Well, first of all, you have to have a criminal law. You have to have the legislature decide that whatever you're doing they decided it's illegal and it's going to be a crime. Uh, for instance, again, sexual assault of people under the age has always been a crime in many, many states. However, doing a sexual solicitation of somebody on the street is different than using a cell phone or a computer to getting on a website and trying to solicit young children. That when the technology started to develop, enabling predators to use computers and cell phones to perhaps solicit young people for inappropriate sexual contact, that became a new thing. The law had to be passed by the legislature to make uses of computers and cell phones for that purpose illegal. Same thing with stalking or threatening. For instance, blowing up somebody's phone with 3,000 text messages or emails can now be charged criminally if it's shown to be threatening and so forth. So laws have developed. So first you have to have a law that says it's illegal, whether it's a theft, a burglary, an assault, a threat, the use of a computer to do something wrong, has to be defined by the legislature as illegal. Well, now we have laws that say what's illegal. That still hasn't started a crime. Now you have to have somebody, a person or a corporation, violate that law. All right. And believe me, we have many, many violations of the law that are not reported, that never come to the attention of authorities. So believe me, there are probably more unreported crimes than actually get reported. Uh, uh, One of the great examples is sexual assault. It's one of the most underreported crimes because people don't want to come forward, and the legislatures have even changed statute of limitations, allowing people to come forward later for things like sexual assault that occurred when they were younger. Uh, Otherwise, they're subject to the same regular statute of limitations. There's other types of crimes that, for instance, happen with regularity that are never investigated or reported or charged. Well, what's a great example? Well, a simple, great example is speeding. You get on any highway, uh, uh, major highway in the United States, especially in interstate, and I just driving down the highway, the speed limit 65. What the whole everybody's moving at like 69, 70, 71. So I'm moving along with the flow of traffic. I'm probably 4 or 5 miles. Oh, don't come and get me over the limit. But I think what I'm doing is reasonable because everybody else is doing it. And we're all going with the flow of traffic. However, I'm violating the law. The entire roadway, with a few exceptions, is violating the speeding law. But first of all, unless it's reported and then investigated, and then the police have the discretion to decide, well, are we going to actually charge this person? In these kinds of situations, as we know, most police won't charge you unless you're going a certain amount over the speed limit. You have to be sort of flagrantly violating the speed limit. That may vary from department to department and the area, the type of road, the conditions, and so forth. But again, speeding happens thousands and thousands and thousands of times, and it's only the more extreme cases that either are seen by police when they're caught on radar, or nowadays people might, if somebody roars by you recklessly, somebody may get their license plate and call 911 on cell phone and say there's a car going extremely fast. So again, a crime has to be defined. The crime has to be violated, but more importantly, before the criminal justice system can come into play, it has to be reported. And again, many crimes occur that are not reported or investigated. There are some crimes that are almost always reported and investigated. Things like bank robbery. It's pretty hard to rob a bank and not have people know about it, report it, investigate it. Homicide, luckily, it's pretty hard. Sometimes it happens. Unfortunately, people disappear, and it's never determined how they die or what happened to them. But in most cases, if somebody is killed or seriously injured, those kind of cases are going to be reported. But cases of burglary, theft, for instance, burglaries happen all the time, and it may be determined by the homeowner or your apartment. You come home at night, and your door's been jiggled around, your windows open, your drawers have been gone through, and you report it, but it's not. Again, it's going to be investigated, but no, it's never going to be determined who did it. So first, you have to have a define what is criminal. Then you have to have a violator. Then it has to be reported. It has to come to the attention of the investigative authorities. And here's another point, folks. In our criminal justice system, I mean, you've heard of what a private investigator. Well, there are private investigators out there on their security forces and things of that nature, but they are not authorized to investigate or prosecute crime. There's no such thing as a private prosecution generally in our country. New Hampshire used to have a, a process by which certain civilians could bring a private sort of criminal complaint against somebody, but that's been eliminated because the problem with that was there was no prosecution review and it only covered most minor violations. The reality is that in order for a crime to move forward in the criminal justice system, it has to be investigated by an authority that has the jurisdiction and the authority to investigate. Has to be a law enforcement. This is the executive branch, a police department, a sheriff's department, a state police, federal police. In the federal system, might be the ATF, might be the FBI, might be Secret Service. Has to be a organization authorized to investigate, to make a determination as to whether or not there is enough evidence. So, again, what here we get to the next step. So, first we have a crime, then we have a violation, then it has to be reported. Now it has to be investigated. Now what happens? Well, guess what? The majority of cases that are investigated, there's never it's not solved or what we call cleared. Police departments call it cleared. Well, cleared can mean many things. It doesn't necessarily mean a charge has been brought. Police may determine that they think they know who did something or what happened, but they don't have enough evidence to arrest. They still consider that cleared. Uh, but in order to move into the criminal justice system, you have to have enough evidence to make an arrest. Now, this is where everything really starts in criminal law and procedure. When the investigative authorities believe there's enough evidence to make an arrest. And how much evidence is that? Well, this is very important. There's several layers of proof in our law system. And there's three layers I need you to understand and remember if you have notes or whatever you want to take notes on this and you want to remember this. The civil standard of proof, that's the proof for non-criminal cases, cases involving negligence, cases involving administrative law, cases involving corporate law, cases involving divorce litigation, and so forth. What is the standard of proof on a civil case? The standard of proof is what we call preponderance of the evidence. Preponderance of the evidence. Let me say that again. Preponderance. And what that really means is you imagine you've all seen the scales of justice, the blind lady holding the scales. Preponderance of the evidence means there's just slightly more evidence in favor of one party or the other. And that's preponderance. In other words, in a percentage standpoint, it's like 51% to 49. Just barely over 50. That's all you need to prove a case in a civil case, a civil standard, like divorce or a suit or administrative law, corporate law, contract violation. All you need is a preponderance of the evidence. That's a pretty low level of proof. In other words, all you got to have is just a teeny bit more evidence on the other side, and you win. All right, that is not the criminal law standard. There are two criminal law standards which I need you to remember, and we're going to get to those. What is the criminal law standard? Remember, we're at the arrest point. The police or the investigative authority has determined there's enough evidence to make an arrest. How much evidence do they need? Well, what they need in order to make an arrest, in order to have it upheld by the court, is a what we call probable cause. Probable cause. Write that one down because that's your next standard of proof. And that is the initial standard in the criminal justice system. And it flows through the criminal justice system almost all the way to trial before it ramps up. But it's much higher than preponderance. It's described many ways in many cases. What I would tell you is probable cause. If you turn, they don't put percentages on it, but I would say something like 2/3 strength, like 65 to 70% positive evidence in favor that somebody's guilty. That's what you would need for probable cause. What it means is more probable than not that you have done what they say you've done and that they can prove it. That's probable cause. Now, you need that in order to make the arrest. And you need that through the initial process or the case is going to be thrown out. So you got to have that probable cause. Now, what happens, as I told you, things ramp up when you get to trial. Can you be convicted on simply probable cause? Can there be a criminal conviction? The answer is no. You must have a higher standard of proof for a conviction. And what I mean is for a trial and for a jury to find you guilty as opposed to not guilty, what is that standard? Remember this one, and I'm sure you've heard this term, beyond a reasonable doubt. That is what a judge will tell the jury in order to find somebody guilty. And if a judge is making the determination, the judge has to find somebody guilty beyond a reasonable doubt. That's a huge ramp up, even from probable cause. Again, there's no judges don't put percentages on it. They've explained it many different ways, but I will tell you that it's significant. It's more than 90% sure. It's not absolute sureness. It doesn't have to be 100%. There's never 100%. There's always some sort of doubt. The question is, you can't have a reasonable doubt. You have to have a doubt that is beyond reason. So you have to prove that beyond any reasonable doubt somebody is guilty. And you are going to have to prove that to all 12 jurors eventually. Or the defendant has to be convinced that they're going to prove it, in which case they're going to work out a plea negotiation, which is what generally happens. So let's review those three standards again. Civil standard, preponderance of the evidence. Just slightly more evidence than the other person. The criminal standard starts with, there's two levels. The first level, to get things started and to get early going in the criminal justice system, is probable cause. Again, you're ramping up to about 65 to 70% sure that somebody did what they're supposed to have done. But for conviction, you go all the way up to that very high bar, beyond a reasonable doubt. That is a high bar. And it is probably the highest bar of proof of any country in any criminal justice system. But that's what we require because we want to be sure, or as sure as we can be, that we're, as I said, in Justice for All, which is one of the few things that was right, that we're doing it right, and that we are convicting the people that are, in fact, guilty, and that we have enough, not only are guilty, but we have the evidence to prove that they are guilty. Even if they are guilty, but we don't have enough evidence, what's going to happen? The case is going to be dismissed. So let's go back to our process again. So the crime's been defined, it's been committed, it's been reported, and each one of these steps, there's crimes that occur that are never reported or never investigated, or they're investigated but they're never cleared. But if you're investigated and it's successful and you get enough evidence to establish probable cause, the police can arrest. That's the beginning of the criminal justice system. And I'll just to highlight the difference between our system and many systems around the world. As I've indicated, in our country, when the police make an arrest, they have to have probable cause. But do we just trust that they will? Do we just say, oh, they must have probable cause? The answer is no. Our whole system is designed to be sure that they do have this evidence and that the system has the evidence. Uh, but in fact, we presume that they don't, and we put the burden on the police, the state, the prosecution to prove that they're right. We don't assume that they're right. In many, many other countries, including many, many civilized, highly developed countries in Europe and so forth, when the police make the arrest, the presumption is they're right. The presumption is they've got it right, and it's up to you to prove that you're not guilty. In our country, the burden is always on the state. So, well, what happens if police always make arrests with probable cause? Well, no, of course not. They do their best. Most police know that if you make arrests uh, and without probable cause, you're not going to last very long as a police officer. I'll just tell you, you're going to be disciplined. You're going to be fired because no department wants somebody that's making arrests without having sufficient evidence. Now, many times you're doing your best. It's a weak case. You're trying hard, but it doesn't mean you're necessarily going to have the evidence. So, uh, if you don't, you're going to be subject maybe to discipline, or you're going to be found quickly. You're going to come in for review, or if you get the reputation in your courts for coming in with cases that are weak, believe me, judges are not going to believe you. Judges are going to start dismissing your cases because you're going to be known to be bringing weak cases. The whole system is designed to encourage you to bring strong cases. But how do we know they're bringing strong cases? Well, I'll tell you. Do we just trust that the police and their supervisors are going to make sure there's probable cause? No. That's why we then bring in the judiciary. That's why we have judges and eventually juries, prosecutors, and so forth. What's the first step? Well, right after an arrest, and usually within 24 to 36 hours in most states, you have to be brought before a judge and you have to be brought to court. This is the arraignment. We've talked about that term, arraignment. Again, it's a common law term. Doesn't mean it's raining. Yeah, it means arraignment actually means you're being notified. Again, early in the common law, way before the Magna Carta, well, the sheriff of Nottingham could throw you in the dungeon, not tell you why you're charged, put old Robin Hood in there, and they didn't have to do anything but hold him down there in his dungeon. Uh, English common law said, especially after the Magna Carta and as it developed, not going to allow that. Somebody's going to have to be notified and going to be given a chance to dispute it. In our system, it's called fair notice and fair hearing. You have a right to dispute it, and you have a right to be told what you're charged with. And again, many countries still in this world, you can be arrested, put in jail. You have no idea what they are charging you with, and no real way to dispute it. In our country, if an arrest is made, you're going to be brought before a judge in arraignment, and the police, and it's usually just the police at that point because prosecutors aren't involved generally. You're going to have to prove to a judge at the arraignment that there's probable cause. Now, how do you have to prove that? Well, again, it's sort of a summary process. It's not a trial at that point, and you don't have to really testify, but you have to produce something under oath, usually an affidavit of arrest. This is a document which the media often gets a hold of later after somebody's been arrested to give you the facts and specifics behind a particular case. They're always looking for that. But at an arraignment, this is an affidavit produced by the arresting officer or by the investigator showing the judge that there is sufficient evidence to establish probable cause. Now, can a defense dispute it? Yes, of course they can. But again, it's a summary process. It's a little bit difficult for both sides. But again, we have to get this going. But if you don't prove to a judge, if a judge doesn't think there's probable cause, what do you think a judge can do? Well, I'll tell you what a judge can do. What a judge can do at any point in the system: dismiss the case with prejudice, which means you can't bring it back. A judge can say, "That's it. This is weak. You're out of here," or "I'm not convinced. You're out of here." Or it may allow you may dismiss the case without prejudice, allowing you to come back if you get further evidence. But at any point, a judge can dismiss the case. So, what else happens in a arraignment? Well, this is where the bail issue comes in right away, because the judge is not going to allow you to be held for pending, because trial is going to be quite a ways down the road, even under our speedy trial. So this is where the question of bail comes up. Again, bail is a common law term, and it means that somebody has to assure their appearance later for the trial. And usually the only question is somebody's reliability to appear. Are they likely to flee? It In some cases, their danger or the level of violence they've used or the danger to a particular victim or society comes into play, but only in the most extreme cases. Uh, Most bail is what we call personal recognizance, which means you just promise to show up. As we talked about, you don't post any money or anything. A bail commissioner comes in, you sign a document saying, I've been charged with whatever, and I promise to show up in a month or two when they want me to show up. And it's only if you don't show up, they then can try to go after you for the money you promised, a bail bond or a bail bond PR bond. Uh, but that very seldom happens. So bail usually comes up right away. And again, if a judge is not convinced that there's probable cause, then you're going to dismiss the case right then and there. Now what happens? Okay, now we've had the crime. It's investigated by the police. We've convinced the police that there's enough evidence to at least establish probable cause. An arrest has been made. We don't necessarily trust the police, so we've gone right away to court. We've convinced the judge there's probable cause. Now what happens? Are we ready for trial? No, we're not even close. What happens next? Well, what happens next is a defendant has the right to question in detail the evidence against them very quickly and do challenge probable cause. And this is called a probable cause hearing or a preliminary hearing in some states. Again, you're going to see this in My Cousin Vinny. Most cases, most movies never show you the probable cause hearing, because it's not very interesting. But My Cousin Vinny, it's very funny. We're going to really take a look at that later on down the line. But you're going to see that there is this hearing. Usually happens within 2 to 3 weeks of the arrest. Now, this hearing is different than the arraignment because this hearing requires testimony, requires witnesses. The state has to produce witnesses, can be questioned by the defense to challenge probable cause. And again, the state at this hearing has to show that they have proof of probable cause. If the judge is not convinced that there's probable cause, guess what? Well, you know what happens. Dismissed. Out. So this is the second major filtering point, the major protection point for the defense. In reality, the prosecutor usually comes into the case, shows the defense the evidence without the necessity of a hearing, and often the defense doesn't want the hearing because they don't want all this evidence getting out to the public. They don't want it on the news. So they waive probable cause. That happens a lot. However, a defendant does not have to waive probable cause. They can ask for the full hearing. And again, if the judge isn't convinced, the case goes out. Now what happens? We're getting ready for trial? No, of course not. What's going to happen next is the case, especially if it's a serious case, a felony case, all felony cases, will go to the prosecutor's office. This is where the DA or the county attorney in New Hampshire, California, it's called the Commonwealth Attorney. Vermont calls it the state's attorney. Everybody calls it something different. In most areas, it's called the district attorney. Their office and their assistants, these are the prosecutors. They come in and they review the case. They take a hard look at the case. Guess what? What do you think happens if a prosecutor determines, well, maybe there's probable cause here, but we're never going to get to beyond a reasonable doubt. We don't have enough. What do you think they can do? I'll tell you. You got it. They can dismiss the case. The prosecutor can dismiss the case. Not the judge. The prosecutor. This is not well understood by the public. The prosecutor has the absolute right to dismiss the case. Now, if you're a victim, you go, wait a minute. That guy hurt me or assaulted me or attacked me or beat me or stole from me. And you're dropping and the victim or the witness, they cannot, they can go to the press, they can do that, but they don't have the power, to prevent it. A judge can't step in and prevent it. No one can prevent it. This is why the prosecution, this discretion by the prosecutor to either change the charge, bring a charge, lower a charge, or completely dismiss a charge is huge. This is prosecutorial discretion. Prosecutors have huge power in our system, and that is why they're the only elected, uh, really, person in the criminal justice system. In most states, judges aren't elected. Obviously, your chief of police isn't elected; they're appointed locally. The attorneys aren't elected. The defense attorneys aren't elected. The bailiffs aren't elected. The appellate courts aren't elected. The one elected position in the criminal justice system is the prosecution, because the prosecutor wields tremendous power. And remember, the prosecutor interest is not, they're not representing the police necessarily. They're not representing the victim. They're supposed to be representing justice. They have the bigger role. They're supposed to look at the case from the overall perspective and decide if justice warrants it going forward or not. They can even decide that there's enough evidence, but they don't think it's a just case or a fair, and dismiss the case. Uh, I can tell you that if a prosecutor violates his oath and goes forward with a case that they know doesn't have the proof, then they can be subject to discipline and disbarred. They can also be voted out. So prosecutors are subject to severe review. Again, in Justice for All, they try to make it look like this prosecutor brought a case with almost no evidence and doesn't think it's ever going to fly. And that's not the case. Prosecutors, it's very, very rare for a prosecutor to violate their duties and go forward with a case. They don't, because they're going to be subject to scrutiny by a judge, by the defense, by the press. If I was a county attorney and I kept bringing weak cases, I mean, you can just see the Keene Sentinel. Oh, the county attorney brings, just case dismissed by the judge again. Bar association coming in. No, you don't want that. Prosecutors have this bigger role. And again, a prosecutor knows that they're going to be standing for election. So if they bring cases that are weak, that are going to be thrown out continually, they're going to lose the election. Now, often we can see prosecutors now, one of the big criticisms of certain prosecutors is that politicization of the criminal process. Some of the things we're seeing with various political figures are being prosecuted for things which may or may not be justified. But one of the issues is, are the prosecutors going too far? Are they extending their power into what otherwise should be a political process? And that's a debate we're going to be seeing and played out in the future here in our country, because it's sort of an unusual way prosecution has been going forward. So, again, take a look at our criminal case. First, you have to have the crime committed. It has to be reported, has to be investigated. The police have to determine there's probable cause. They have to go immediately. You have to go before a judge at an arraignment. You have to show the judge's probable cause. Several weeks later, you have to have a full evidentiary hearing. You have to prove again to a judge's probable cause. And the judge can throw it out. Now you're going to the prosecution for a full review. And if the prosecutor doesn't think, not only is there probable cause, but the prosecutor has to look further down the road and make sure he or she thinks the evidence is sufficient or going to be sufficient for a conviction. If they're not convinced, the prosecution dismisses the case or changes the charge or lowers the charge. Okay? So all these things are now are we ready for trial? No. No, folks. No. We're still almost in the middle, because what happens then is we have the discovery process. One of the things you'll see in the media that, again, most people don't understand is that people believe the prosecution can play this sort of hiding the evidence game or not revealing the evidence. And the reality is all evidence against the defendant has to be turned over to the defendant. And not only evidence against the defendant, but what we call exculpatory evidence, evidence that might show that the defendant is not guilty or the defendant didn't commit the crime. A witness that says something different, or DNA that shows something different, or fingerprints of somebody else, or blood of somebody else. And the prosecutor is not allowed to hide that. And if they do, they violate the case is what? You know what happened to the case? Dismissed, and the prosecutor is going to be in trouble from a disciplinary standard. They have to turn over all the evidence to the defense. And the defense gets to know what every witness says. Every time there's a witness statement, any scientific evidence, examinations of the evidence, they get to know it all beforehand. And that's only fair. the defense, in order to prepare a defense, has to know what the evidence is. So in order to dispute it, again, other systems, other countries are not so complete about this. Many systems allow the prosecution to limit the revealing of certain evidence or hiding certain evidence. Our country does not. And this is called the discovery process. But again, you can sort of imagine it. Just imagine in the context of a athletic thing, such as a football game, being a coach and developing your play plan and your plays and your secret thing, and having to turn all that over to the other coach the night before the game, so they know what you're going to do and how you're going to do it, and what your plays are. Well, of course, uh, it's hard to imagine, but that's the way we do it in the criminal justice system. All right. Now we have the discovery process. Now the defense knows what you're going to do. Are you ready for trial? No, no. We still have to go through a very important part of the criminal justice system for any and all felonies. One you've heard about many times. Most people, again, don't understand the significance of this particular phase of the criminal justice system, but it's important. That is the grand jury. Our system requires that the prosecutor now not only be convinced themselves that they have a case and have convinced the judge that they have a case and shown the defense what their case is, they have to convince regular people, I mean citizens, untrained, non-lawyers, that they have a case. And they have to convince these citizens to approve the case. That's called an indictment. I know you've heard of this. This is the grand jury looking at a case. What is a grand jury? Well, a grand jury means it's not a trial jury. A grand jury is grand only because it's bigger than a trial jury. How many in a trial jury? Well, we call that the petit jury. Those are 12. Grand juries are usually at least double the amount of petit juries, so at least 24 in most states. And they're in a big room. What are some of the differences in a grand jury? Well, a regular jury sits there in the jury box. They don't ask any questions. They're not allowed to raise their hand and say, I'd like to ask the witness question. In a grand jury, the jurors get to ask questions. Yes. And now, again, they're only looking at probable cause, but the prosecutor has to come in with evidence and demonstrate to the grand jury and convince the grand jury that there's enough evidence to keep going. Now, grand juries, I will say this, grand juries are one-sided in that the defendant is not allowed to be there, not to be able to present the defense side. And you say, well, gee, how is that fair? Well, again, the jurors are told by a judge that they're really supposed to be devil's advocate. They're supposed to come in and go, wait a minute. They're supposed to question everything. And they're supposed to question. They can question the witnesses themselves. They can subpoena witnesses. They can call witnesses if they want to hear from people. They can question a prosecutor. And reality is, prosecutors really want to hear from the grand jury. When I was a county attorney, I would be fascinated to know, especially on close cases where I thought maybe as an attorney I had enough evidence, but I don't know how a jury would react to a certain witness or a certain piece of evidence. You want to bring it before the regular grand jury and say, hey, folks, what do you think? Are you troubled by this testimony? Do you believe this testimony? Do you believe in this case? Do you think it's a weakness? Where do you think it's weak? You ask, and the jury reacts. They're allowed to tell you things. In the end, though, you leave, and the grand jury votes on whether or not to indict. And when they charge, an indictment is just a charge, a formal charge, usually written up in legal language by the prosecutor. But the grand jury has to decide there's enough evidence to bring that charge. And they have to, the foreman of the grand jury takes a vote. It's just majority vote, though, not complete agreement, not unanimous like the trial jury has to be. So it's only a majority. But again, if you're a prosecutor and you can't convince by the way, if the grand jury doesn't indict, what happens? Guess what? You know what happens, right? Case dismissed. I've had several cases as a prosecutor where we would go to the grand jury and we'd simply say to them, this is a closed case. Folks, this is could go either way. We want you to decide what you think of it. Tell us. And I've had several cases where grand jury says, we don't think there's enough. We have questions and we're not going to indict. And when the grand jury doesn't indict, guess what? at the end of the case. I can't go forward without the grand jury. Uh, and I don't want to. No, if you can't convince 24 people on a majority basis, you're certainly not going to convince the 12 at a trial unanimously. So again, it's a great tool to the prosecutors to know what cases are strong, what cases are weak. Often, if you understand that there's weaknesses in a case or they don't believe somebody, then it's going to be a motive to maybe plea bargain or change the charge or drop the charge to a more appropriate charge. It gives you all sorts of guidance. But again, it's a very crucial point in the criminal justice system and a very key safety valve, a filter, if you were, just like all these other spots, the arraignment, the probable cause hearing, the prosecution review, the discovery, and now the grand jury. So, at any one of these points, weak cases get dismissed. Now we have the grand jury indictment. Are we ready for trial? You, you guessed it. No, we're not. Now we're going into what we call the pre-trial phase, where the defense now has all the evidence, and now the grand jury decide to go forward. The defense gets to challenge the evidence. They could determine that it wasn't properly investigated, that search warrants weren't properly issued, or if they were issued with improper background information. They get to challenge the evidence. And in Justice for All, again, one of the things we'll talk about next time about that movie specifically. Remember the big thing about the polygraph? Oh, several times Al Pacino mentions the polygraph. Well, folks, in reality, if there were evidence like a polygraph, if either side wanted to use it, they would have to have a pre-trial hearing about it. You don't do that in front of the jury. You don't jump up and scream and yell and so forth. No. You go before a judge. If you're going to challenge a confession, if you're going to challenge a piece of evidence, or you're going to say the fingerprints weren't properly obtained, or the DNA wasn't properly obtained, or this polygraph should or should not be admitted, that has to go before a judge before the trial. So the judge can make a ruling, which then can be appealed later. So the judge allows something in and a person's convicted, that can be one of the appeals. Oh, the judge allowed that evidence and you challenge that. But you don't wait till the trial. In movies, they always have you waiting till the trial because it's so dramatic to jump up and object. Now, there are some objections at trial, but nothing like you see in most of our movies because most of the evidence issues have been determined before trial. And why do they want to do that? Because, again, once both sides know what evidence is coming in or not, now, are we ready for trial? No, now both sides are going to negotiate because let's say this witness has been ruled they're not going to be able to testify, or certain parts of their testimony are going to be eliminated, or certain evidence isn't coming in. Then as a prosecutor, I got to rethink my position and maybe take a lower level plea negotiation. If I'm a defense attorney defending my particular client, I may look at it and say, well, now we have a more of a chance, but it's still a huge risk. Let's maybe plead to something lower. Everybody will look at the judge's determinations in deciding whether or not to go forward with trial. And all that takes time. So, folks, let's just look at this a second and just look at the protections, the screening, the safety valves to make sure that cases that get all the way to trial are strong cases. Well, first, you got to convince the police that there's probable cause. And all right, police don't always get it right. They sometimes either intentionally or unintentionally don't get it right. But we're not going to rely on that. Now the police have to go to court, convince a judge at an arraignment. And a judge has to be convinced of it. And then you have to have a full evidentiary hearing and a probable cause hearing. And you got to convince a judge again that there's probable cause. At any one of these places, it can be dismissed. And then you got to go to the prosecutor's office, and the prosecutor's got to be, because their reputations and lives, their livelihood is on the line. They have to look at the big picture and look at justice. And if they're not convinced there's enough evidence, they dismiss the case. Now you have discovery and let the defense know all the evidence, right? And they can object. Now you have to go to the grand jury and convince 24 or more regular citizens there's enough of the case. And now you got to go before a judge on the particular evidence and show the judge all this evidence gets to come to trial. And a judge can eliminate that evidence. And now you're getting close to actual trial. Guess how How long that takes can take months and months, usually more than a year. Year and a half is common to get from A to B. And at any one of those points, the weak cases can be dismissed. So you now can see, I hope, why most cases that get to the end of that process, getting ready for trial, the strength of the state's case is fairly strong. And most cases end up with a plea bargain or plea negotiation. Because even though the state's case is strong, it still relies on testimony. Real witnesses getting on the witness stand. And as we talked about, that can be a disaster. It may sound like you have a good witness. I've seen witnesses completely freeze up on the stand. Can't even tell the jury their name or where they live or what they saw because they're so frightened, they're so nervous, they're so upset. I know you know what I'm talking about because you've probably been called up in school here to read a paper in front of a class or make a statement or stand up. We all know how unnerving that is. Most people have to go to a special course to learn how to be a public speaker, how to stand up in front of people, how not to be embarrassed. Well, guess what? Most witnesses have never had these courses. Most witnesses are scared to death to actually get in front of somebody, even if they're reading something, let alone being questioned on things they're supposed to remember without notes. No jurors allowed to have their notes. I mean, the witnesses can't sit there with their statement in front unless somebody actually shows it to them for a specific reason, highlights a certain area. The witness is on their own to use their memory. So you can, again, imagine where that goes. Now, and let's say we get a trial, and by the way, we're going to go through all the portions of the trial, the jury selection, the opening, the witness testifying, the closing. Now the jury has to make a determination. And folks, even if the jury finds beyond a reasonable doubt now that somebody's guilty, is it over? No, of course not. Now we're going to appeal. Now we're going to those judges. We're going to talk about that later. So again, let's just think of the procedure. What I want you to do, folks, for next time is just think about this. Think of all the filters and safety valves we have built into our system to try to make it as good as and it's not foolproof, but as uh, worthwhile and as trustworthy as we can. And we're always improving it or trying to improve it. But at any point in these cases, and we're going to talk about some real cases where many cases have had to be dismissed where you think it's fairly strong, which, again, if you're a victim or if you're a witness and you're frightened of someone or somebody's been threatening you, hurting you, stole from you, robbed you, beat you, and the prosecutor, or the police, or the judge dismissed the case because they don't think there's enough. You're like, what? 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 Yeah, most the people don't understand. So think about this. First, you convince the police that that the person did, and you can prove it. Then you got to prove at the arraignment to the judge. Then you got to prove it at a probable cause hearing. Then you got to prove it to the prosecutor after a thorough review. Then the prosecutor has to show everything to the defense. Then you have to go to the grand jury and convince all of them. Then you got to go back to the judge and show the particular evidence gets in. And then if you don't get it resolved, you got to go before 12 people, regular people, and prove unanimously that you not only that you have there's no reasonable doubt that you have the right person. You have to have no reasonable doubt. You got that's like a 95 to 98% assurance. And even then, now you're convicted or you're not even done. Now you're going to appeal. And any errors can be overturned. This is one of the reasons I like our system so much because we work so hard to get it right. So, folks, next time I'd like you to read, if you can, chapter 3. Start thinking about the 4 levels of mental intention that have to be proven at these various stages. Either purposely, knowingly, recklessly, or negligently. And you know what we're going to do next time? We're going to take a clear example of maybe the same act, actually the same action by somebody. And depending on how they approach it mentally, it can be an accident. It can be no real crime to something that's simply a civil liability situation. to something that is low-level criminal, to medium criminal, to, to felony level criminal, all the way up to capital level murder, depending on how things are approached mentally, whether it's purposely, knowingly, recklessly, or negligently. So read chapter 3, read the Shepherd case, uh, enjoy criminal law as I do, and now you're going to have a whole new view as we move forward. Folks, I look forward to seeing you next week. Thanks so much to all of you. I wish you all a good night. We'll see you next time.